I would like to first thank the sponsors and organizers of this event, and specifically my friend and colleague, Adam Turner. Thank you so much for your work and for putting this together. And I'd also like to thank my colleagues. It's a privilege to be on a panel with each and every one of you, and it's also particularly a privilege to finally get to meet you, Claire. So, but I'd like to especially thank all of you, the audience, for being here today and taking time from your schedules to educate yourselves on what I think is a very important issue. I truly appreciate this opportunity to speak with you and hope that my words might be able to provide some useful insights in terms of understanding the significance of and even how we might respond to resolutions like Resolution 1618, this so-called Istanbul process, and the apparently shifting position of our own government with respect to defending in the international sphere one of our most cherished freedoms, freedom of speech. When Resolution 1618 was introduced and eventually adopted by the Human Rights Council without the term defamation of religions, that event was seen as a major victory. Both a defeat of the concept of defamation of religions and a victory against the OIC in its efforts to impose restrictions on freedom of speech and expression. That event was described by some as a landmark achievement, a substantive, not merely tactical victory, and a significant move away from and even a laying to rest of the concept. And when I was here last February participating in part one of this discussion, I argued that it was none of these things. To briefly summarize my points from that discussion, I argued first that despite any claims to the contrary, the concept of defamation of religions is not dead. And that two, we are worse off today than we were today in our efforts to protect freedom of speech than we were before this compromise resolution with the OIC. On the first point, as they say, the ink was barely dry on Resolution 1618 when the OIC was already describing the resolution in defamation of religion's terms. Basically, the OIC saw the resolution as having the same end, whether the West chooses to see it that way or not. And incidentally, and I think not so surprisingly, the OIC still sees and describes Resolution 1618 in these very terms. Just this September, OIC Secretary General, in referring to it, explained that the OIC had, quote, succeeded in convincing the Human Rights Council to adopt by consensus Resolution 1618 on defamation of religions, which condemned unequivocally attempts to discriminate against persons based on religion or belief. So it's not dead. And on the second point, that we are worse off post-Resolution 1618, I've argued that we lost valuable allies in the resistance against the OIC's efforts. While allies in the West were able to rally against the defamation of religions concept, they weren't similarly positioned intellectually to resist the same idea when it was couched in hate speech terms, which I think is how this current resolution is written. And this is partly because they've already accepted this hate speech concept as legitimate and have incorporated it into their legal system. So how could we have expected them to resist it? And moreover, how could we have expected them to resist it when we were the ones pushing for it? And then on top of all of this, in exchange for what I think is merely a cosmetic change to the language, not a change to the agenda, we gave the OIC a seat at the table as equals to address issues related to freedom of speech as part of this Istanbul process, which was about implementing, putting into practice Resolution 1618. Now, there were several issues that baffled me, that puzzled me when Resolution 1618 was adopted, and they continue to puzzle me a bit today in regard to this decision to compromise with the OIC on speech issues. The first thing is, it baffles me that anyone believed that we could compromise on the issue of free speech and our free speech rights without diminishing this fundamental right. Now, compromise has its place if you're deciding where to go to dinner or whether your kids' curfew should be extended, but compromise has no place with regard to your principles. Your principles are flawed, you have to examine them and fix them. But if they're right, you can't compromise on them without eroding. And with regard to hate speech, I think the United States position on this is actually correct. We don't prescribe it. And we're the last holdout, I think, in that regard. Our current position is that if freedom of speech is to mean anything, it must include the right to offend. And to quote from a Supreme Court decision, I think Sam alluded to this, Texas versus Johnson, if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds that idea itself offensive or disagreeable. And so, both because I think our position on hate speech is correct, and also because this is a fundamental, or actually foundational principle upon which our freedom of speech protection is based, I don't think that we should make the mistake of compromising with the OIC on this principle. Any compromise between our and the OIC's position on what should be acceptable boundaries of freedom of expression would necessarily lead to the erosion of one of our most essential and cherished freedoms. And for evidence, we need only look to Europe and the selective application of hate speech laws there and the proliferation of hate speech prosecution to see the direction in which a little compromise on this issue will take you. And we need only look to OIC member states and the abysmal state of human rights there with regard not only to freedom of speech, but religious expression and other fundamental freedoms, to see where the OIC's concept of freedom of speech will take you if it's put into its full effect. The second issue, the thing that bothered me about this decision to compromise with the OIC on speech issues, is that anyone could have had a doubt as to the direction the OIC meant and indeed means to lead us. If anything, the OIC has been crystal clear on its agenda. The Cairo Declaration of Human Rights on Islam sets forth the OIC's concept of what constitutes legitimate freedom of expression. It reads in relevant part, everyone shall have the right to express his opinion freely. Well, so far, so good. But here's where it goes wrong. In such a manner as would not be contrary to the principles of the Sharia. So there it is in black and white. Now, if you didn't get it then, when it was written pretty clearly, it was underscored again in the late 1990s when the OIC first attempted to outlaw what it called then defamation of Islam. If you still missed it, and despite the changes then, and I know Deborah's going to speak in more detail about this, to the change of the term to defamation of religions, the discussions surrounding resolutions on combating defamation of religion all talked about defaming Islam and made clear, again, the OIC's position. So for years now, it has been the goal of the OIC to place limits on expression that it deems offensive to or critical of Islam or Muslims. And we're seeing, and Adam set forth some of the examples of what constitutes defamation. It doesn't have to be false. It doesn't even have to rise to anything that would be alarming in our country. So, and political satire is defamatory as well. So that anyone believed that there was a shift in the OIC's position in a meaningful way is frankly shocking to me. The third thing that baffled me about the decision to compromise with the OIC on speech was the terribly unfortunate timing of the decision. And this is related to a point also that Sam made. At the point the West, led by the United States, decided to move forward with Resolution 16 and support this, support for the defamation of religions concept was already waning. And it had been steadily eroding, the support for it had been steadily eroding for years. And left alone, it might very well, and I wish that it would have maybe died a natural death at the UN. But we'll never actually know that. But it was exactly at this moment that we decided to strike a compromise with the OIC. And I think this was a critical error. As I've already remarked, the effect of this decision to support 1618 necessarily compromised our own principles. And this decision was made in exchange for effectively no change in the OIC's policy toward freedom of speech. So basically, we helped the OIC repackage and revive a dying concept, and we helped them to repackage it in a way that's actually harder for our allies to rally against. And so at this point, you may be wondering, what the heck were we actually thinking when we did this? And I think, though, I've puzzled over these issues, and again, they're still troubling to me, but I think the more important issue is what do we do now? And I think that some of the solutions actually lie in the very questions, the issues that I found troubling when the 1618 compromise was adopted in the first place. I think the first thing we have to do is start with our own principles. What does the United States stand for with regard to protections of freedom of speech? What are our principles, and are we right? And if we are, those principles are right, we must be prepared to defend them, even in the face of an apparent consensus to the contrary. And that's where we are with regard to hate speech laws. And that's, again, I think where the business of Resolution 1618 and sequelae go. It's no longer couched in the terms, literally, of defamation of religion. The second thing I think we need to know is what our opponent's position is. What are his principles? And if they're wrong, why are they wrong? We have to ask ourselves whether we'd like to live under those principles. You know, what would it be like to live under, in this case, the question is, I think, pretty simple. Do we want to live under a system in which freedom of speech is circumscribed by the Sharia, as set forth in the Cairo Declaration? I hope your answer to that question is no. And yet, it's critical in this that we allow ourselves to see our opponent's position for what it is, what it actually is, and that we don't attempt to delude ourselves, which I think is a little bit what we've done here, wishful thinking to make it something that it's not. Now, some of that might seem simple, and maybe even a little simplistic, but I don't think we actually ask ourselves these questions, and I think that's why we've ended up compromising on some of our essential principles at the international level. And I think a third step that might be helpful is incorporating our allies. So once we get 1 and 2, what we stand for, what the other guy stands for, we can work to convince our allies of our position. And in the meantime, as we're working to convert people, so to speak, we can make common cause with those who already agree with us. And even as we are, I think, allowing our precious freedoms to slip away, there are Europeans who have been at the business end of these speech restrictive laws who are calling for the adoption of a First Amendment type protection in Europe. I was actually asked to speak in Europe about this very issue. And there are also Muslims, both here and abroad, for whom the OIC does not speak. And I'm talking specifically about ones who want separation of church or separation of mosque and state. And if we're choosing to ally ourselves with a particular group in Islam, we have to choose men and women who wish to be free and not the Organization of Islamic Cooperation. And so I think it is the single greatest hope in preserving our freedoms and defeating the OIC in its speech restrictive agenda that we have an informed and engaged American people. I think knowing who we are, knowing what we stand for, and knowing what they stand for, and being prepared to do battle on these issues, I think are the first critical steps to getting them. Thanks.